Welcome, everyone, to part one of our two-part session on the prevention of workplace harassment and violence, roles, responsibilities, and reporting. My name is Sue Freeman. I'm an outreach program manager here at the Canadian Centre for Occupational Health and Safety. I'm an advocate for healthy workplace programs and have a background in workplace mental health. I am joined today by our Manager of Public Health Partnerships, Sonia Tonkovich, whom too is a healthy workplace advocate and has extensive industry experience and is a certified health and safety professional. Welcome, Sonia. I'm
Thanks, Sue. Happy to be here. Hi, everyone.
going to start with a land acknowledgement. To begin, I'd like to acknowledge that CCHS is situated on the traditional territory of the Haudenosaunee and Anishinaabeg, on territory covered by the Upper Canada Treaties, within lands protected by the Dish with One Spoon Wampum Agreement. In the agreement, the dish represents the territory, and a single spoon represents that the people are to share the resources of the land, taking only what they need. We also acknowledge that the legacy of colonialism continues to impact Indigenous people today. We commit to seeking a new relationship with the original peoples of this land, one grounded in honor and deep respect. Thank you. Content warning. It is important to note harassment and violence affects the lives of many workers in Canada. This content may be difficult or upsetting for some learners. We encourage you to take care for your own safety and well-being and to take breaks as needed. Please ask any questions you have in the Q&A section. In terms of CCHS, the Canadian Centre for Occupational Health and Safety, we are Canada's national resource for the advancement of workplace health and safety. For over 40 years, CCHS has promoted the physical and psychological health, safety, and total well-being of workers. We do this by collaborating and engaging stakeholders and providing information, education, tools, and solutions that will help prevent work-related injury and illness and to improve the lives of workers. CCHS is a federal department corporation reporting to the Parliament of Canada through the Minister of Labour and is governed by a Council of Governors representing governments, federal, provincial, and territorial, employers, and workers, a structure that ensures a balanced, impartial approach. And now I'll pass it to Sonia.
We are going to discuss the federal regulations regarding workplace harassment and violence. So what do you think of when we talk about harassment and violence? Take a moment to think about it and perhaps use the chat feature to share your thoughts. Just give you a minute here. Unwanted acts, bullying, fighting, inappropriate comments. Yep. Aggression, microaggression. Thank you. Lots of good points there. Thank you. So all too often, a lack of civility and respect are often at the root cause of violence, harassment, and bullying issues within workplaces. How did those of you in leadership roles champion and prioritize a civil and healthy workplace before it gives way to a toxic culture, which might be ripe with resentment, rudeness, and violence? A crucial part of any healthy workplace is a workplace violence prevention program that outlines preventative measures against all forms of harassment and violence, including sexual, domestic, and workplace. Whether driven by legislation or motivated by doing the right thing, policies and procedures need to be comprehensive, supported by leadership, and underscored by an environment that values respect, consideration, and professionalism. Today, we are focusing on federally regulated workplaces in terms of harassment and violence prevention. However, even if you're not in such a workplace, there are many ideas that we're sure you can take away from and reflect on and look at your own jurisdiction's harassment and violence legislation and regulations for more specifics. Further support your policy, prevention, and taking action. So occurrence means an occurrence of harassment and violence in the workplace. An occurrence can be an incident, event, spoken words, or an email. Those are just a few examples. It can be a single occurrence or a series of events. An act, it is something that is said or done. It does not have to be a punch or a push or a shove. It can be subtle because what matters is the impact. So impact, it is the effect on another person in some negative way. The definition in the regulations uses reasonably in it, as in reasonably to be expected. The reasonably test is generally considered to be what would most people consider this? Would most people consider this to be harassment and violence? A workplace may experience that there is a fine line between strong management and bullying. Comments that are objective, are intended to provide constructive feedback, are not usually considered bullying, but rather are intended to assist employees in their work. So as described by WorkSafe BC, for example, and their fact sheet information, bullying and harassing behavior does not include expressing differences of opinion, offering constructive feedback, guidance, or advice about work-related behavior, does not include reasonable action taken by an employer or supervisor relating to the management and direction of workers or the place of employment. For example, managing a worker's performance, taking reasonable disciplinary actions, and assigning work. Location. The definition of workplace in the federal jurisdiction means any place where an employee is engaged in the work for the employer's employer. So any place the employee is engaged in work for the employee's employer. Therefore, an employee's workplace is not limited to only the building and facilities that have been provided to them by their employer. Instead, an employee's workplace follows them wherever they are performing that work for their employer. An employee's workplace can include public spaces or third-party premises. Given this interpretation of workplace, if an employee is exposed to harassment and violence at any location while performing work for their employer, this would constitute an occurrence of harassment and violence under the regulations, and incidents that arise out of or are linked with employment, such as incidents while on travel status or after-work functions organized by the employer. Workplace harassment and violence can arise from a person within the organization, such as a coworker or manager, a person related to the function of the workplace, such as a patient, a client, a customer, a contractor or student, a person with an indirect relationship with the workplace, such as an estranged spouse or partner, or even a former employee. It can also arise from a person who is unrelated to the organization, such as a member of the public or a person with criminal intent. Some other examples include removing areas of responsibilities without cause, constantly changing work guidelines, establishing impossible deadlines that will set up the individual to fail, and withholding necessary information or purposefully giving the wrong information. These examples on screen emphasize verbal abuse or intimidation examples, and the important note at the top is your workplace encouraging people to self-reflect so that prevention of such behaviors and circumstances can be stopped, or at the very least be mitigated. Principal party and responding party. The federal workplace harassment and violence legislation introduces the terms for principal party, that is the person who has experienced the harassment and violence, and the responding party, the person who may be asked to respond to the occurrence. Overall, it is important to know that the response process is largely driven by the principal party as the person who has been the object of the occurrence. Also, it's interesting to note that a witness can report too. The person experiencing the harassment and violence is not the only one who can report an occurrence. Sometimes the person experiencing the harassment and violence may not recognize that the situation they are involved in meets the definition of workplace harassment and violence. Sometimes they may be embarrassed or worried about what might happen next. The designated recipient, the unit or person to whom you should report workplace harassment and violence to. This person or unit will be identified in your employer's workplace harassment and violence prevention policy. This person or unit will have special training on how to assess and respond to occurrences. The person or work unit does not need to be an employee in the workplace. For example, the designated recipient could be in the community or could be an association or third-party organization that has been hired to fulfill the role of a designated recipient. A work unit could refer to a group of people, such as the Human Resources Department, the Labor Relations Department, etc. Consideration should be given to the person or work unit having no direct personal or working relationship with any of the parties involved and no personal interest in the outcome of the matter. The ability of the person or work unit to ensure that the confidentiality and privacy of the matter is preserved to the extent required by the applicable legislation. More about the role of the designated recipient. These conversations may become very emotional. A level of empathy and compassion is needed. While participating in further activities such as the negotiated resolution, consider looking for ways to help the principal and responding party resolve the situation. Keep in mind that many occurrences of harassment and violence may not be a single event, but rather it is common to be a number or series of events or a pattern of behavior. The applicable partner. Throughout the regulations, the duties of the designated recipient, applicable partner, as well as our usual policy committee, workplace committee, or health and safety representative are indicated. In some cases, these duties or roles are not interchangeable, so look out for that. There may be other duties. Please refer to the highlights on the slide. From hazard identification and risk assessment through to working jointly to create and implement prevention plans, this joint effort between employer and the applicable partner, such as your workplace health and safety representative or committee, helps to ensure that the steps are being followed and are jointly conducted. Many of these measures listed on screen are to protect the identity of the person or persons involved in an occurrence. Those persons would primarily be the principal and responding parties. Maintaining confidentiality and respecting the privacy of those involved is critical to a positive outcome and a respectful workplace. For example, other employees may need to be alerted to general safety issues, such as an aggressive person known to frequent a particular parking lot, or a customer who is known to be difficult, while in other situations, employees may not need to know the identity of the involved parties. I'll pass it back over to Sue.
Thank you, Sonia. We're looking at Section 13, which specifically describes a list of employer duties, including prevention and protection measures, responding to occurrences and offering supports, as well as following joint duties, working on the resolution process, training employees, and making sure that the employer ensures that the designated recipient can fulfill their role, as well as a workplace's requirement to report incidents to the Federal Minister of Labor. Risk factors. The regulations specify that the employer and applicable partner must jointly conduct the workplace assessment. The goal of the workplace assessment is to understand and record the risks that may be present in your workplace or risks you're exposed to as the result of your workplace, and the assessment must examine internal factors, including the culture, conditions, activities, and organizational structure. External factors, including family violence that may occur in the workplace. Any reports, records, or data about harassment and violence. The physical design of the workplace, any measures that are in place to protect psychological health and safety. And for the workplace assessment, these preventative measures must be developed and implemented within 6 months after the risk factors are identified. Under Section 9 of the regulations, it states that the employer and applicable partner must work together to develop preventative measures that will help to reduce risks and not create any further risks. Develop a plan to put these measures in place and to implement the plan. These preventive measures must be developed and implemented within that 6 months after the risk factors, again, are identified. Besides what is listed on the slide, other policy elements include the employer's commitment to prevent and protect employees against harassment and violence, as well as listing training that will be provided about workplace harassment and violence, and it's very important to note that the employers and their representatives must provide training to the designated recipient. In looking at Section 10 of the regulations, it considers including the emergency procedures that must be implemented when an incident poses an immediate danger to the health and safety of an employee or when there is a threat of such an occurrence. Describing any recourse that may be available to persons involved in an occurrence, and naming the person designated, as we mentioned earlier, designated recipient, to receive complaints related to the employer's non-compliance with the code or regulations. So in terms of emergency procedures, they may apply more in some workplaces than others. But for example, if a client is being very verbally abusive to staff, what are your procedures to end this situation? You can put some ideas in the chat, but some are how to call for assistance, when to evacuate or shelter in place, when to call 911 for outside assistance. Employees and their applicable partners should take into consideration any of the following occurrences or threats of occurrence that may make their way into the workplace. An ex-partner or current partner, family member, member of the public, or other third party assaulting, stalking, or threatening, either verbally or text, email, social media, to harm the employee outside or inside of the workplace. A verbally or physically violent person, a bomb threat, or an active shooting situation. Many employers offer access to a number of additional resources, including Employee Assistance Program services, known as EAPs, referrals to supports for family violence, as well as other supports. The federal regulations state geographical area, but if you are in a remote or underserved area, reaching out to a national organization or those with online services would be good too. Employers could include information on community programs such as shelters for family violence, mental health, food banks, suicide crisis lines, sexual assault services, and counseling services. Depending on your workplace, people can contact the designated recipient, your human resources advisor, or union representative for additional information. When we say why is reporting important, every workplace is required to have a process for reporting, recording, and investigating occurrences. Workplaces have a duty to report all occurrences, actions, conducts, or comments must be reported, as well as being followed through, using the process outlined in the regulations. Reflecting on the importance of reporting, including how concerns left unreported cannot be addressed, means that unfortunately the situation may continue or worsen, as such incidents are not known to go away on their own without intervention. As another important point, there are federal regulations that outline the process for federally regulated workplaces to follow through to achieve an outcome or resolution that can be implemented for the safety, health, and well-being of all the people affected. If you are not a federally regulated institution or organization, please review your own jurisdiction's harassment and violence legislation and regulations for specific information and guidance. In terms of the notice of occurrence itself, it doesn't contain all of the information necessarily required by Section 16 of the regulations. The principal party or witness themselves should be given the opportunity to provide the missing information. Encourage the person to provide as much detail as they can. So from Section 16 of the regulation, it does state in the content of notice that a notice of occurrence must contain the following information: the name of the principal party and the responding party, if known, the date of the occurrence, and a detailed description of the occurrence. However, if the notice does not contain sufficient information to allow the identity of the principal party to be determined, an employer is not required to take further action to resolve the occurrence and may therefore deem the occurrence resolved. There are many steps past the notice of occurrence being filed, which starts in Section 14 and goes through to Section 19 of the federal regulations. In Regulation Sections 20 to 30, you can find steps to take for the initial review, plus the conciliation, investigation, and other requirements. And now I will pass it back to Sonia. Thank you.
Okay, so just a reminder that CCRHS has many harassment and violence prevention resources for both federally regulated workplaces as well as other jurisdictions in Canada. From infographics to fact sheets, podcasts, and online courses for workplace prevention training and purposes, CCRHS can help you with your harassment and violence prevention program needs. You can visit our website and social media channels to find out more. So now we can take a few minutes to review what type of questions we have received from some of you during our registration time permitting. Questions for the chat window today as well. Then we'll see if we can answer them. We'll do the best that we can, or indicate that we'll get back to you if we need some more time to get the information. We do have some questions that came through earlier. One of them is the health and safety officer involved in harassment investigations, or is it only human resources responsibility? So that's a great question. And the answer is whether health and safety officer or human resources is involved would really depend on your workplace harassment and violence prevention policy and program. A work unit or a person can be named by the employer as a designated recipient. It would also depend on the workplace and how the employer organizes the work unit's responsibilities. I hope that is the answer you were looking for. Another question that's come through, do the EDI, so equity, diversity, and inclusion committees, do they have responsibility regarding workplace harassment and violence? They could. It would depend on your workplace harassment and violence prevention and policy. Again, for example, if the Equity, Diversity, and Inclusion Committee may be named as a designated recipient if the workplace chooses to include them in that program. If they are, they must receive training related to that role within the program. They may also be used as a resource to help us create training and education resources for the prevention of workplace violence and harassment. Okay, let's see some more questions coming through. I have another one here. What would it take for charity staff with a status that's regulated through the CRA to be covered by the Canada Labour Code Part 2? And what is the criteria to qualify? Interesting question. CCOHS is not in a position to give any opinion on the jurisdiction that regulates charities. Employers are advised to retain legal counsel to determine the applicable legislation or to contact the labor program directly. The Canada Revenue Agency also registers charities in Canada and makes sure that they continue to comply with the requirements of the Income Tax Act and common law. For most people in Canada, the agency that you need to contact is provincial or territorial agency in the area where you work. Also, the federal health and safety legislation is commonly referred to as the Canada Labour Code Part 2, and the regulations are under the code. The Canada Labour Code also applies to employees of companies or sectors that operate across provincial or international borders, as well as employees of federal government and crown agencies.
Thank you, Sonia. It appears that we have some very interesting questions in the chat. And I was going to ask us both to tackle at least one of them. We have some time left today. And the first one was, if we propose this to our employer to implement and they refuse, what action do you recommend? Now, I was going to start off with, and pass it back over to you for further thought, that we've just really wound through about half an hour time of what regulations are the requirements and form the basis of what needs to go into people's harassment and violence prevention policies and their programs and their practices. So my initial reaction is I'm not sure what grounds they're refusing on, or if there's a lack of that happening in the workplace in terms of a prevention mechanism. So, any other thoughts on that in your health and safety practices?
Just thinking, if your employer is refusing to follow the legislation, you do have recourse. You can contact the labor program in the federal jurisdiction, as well as the occupational health and safety regulator if you are in a different jurisdiction. And I would recommend doing that. So there are requirements under the law. And the regulator can also interpret the legislation. So CCHS can't do that, but they can interpret the legislation and determine what is being followed, if you will, and what is not.
Thanks, Sonia. And similar to that, someone was asking about what resources would we recommend to escalate complaints that are disregarded by an employee's workplace. And in this instance, they are not federally regulated, but just in general. Again, we can refer them back to what you were just saying about there's different entities that are provincial or territorial. So, would you concur with that?
Yes, absolutely. I would say start in the workplace. So look at your supervisor, human resources, what other units you might have in the workplace that might be able to help you, as well as the workplace health and safety committee or representative might be able to help. And then you can also turn to your union if you have one. And following that, you can look at contacting the health and safety regulator in your jurisdiction for more support.
Yes, these are excellent questions. They're very practical, and we want to refer people back to what we were discussing today as well and see what's happening within their own existing policies and procedures, like what is listed, what is evident to be followed. And maybe some of the things that we discussed today could also be included if they're not already there or apparent. So I believe that might be the extent of questions in the chat today. So I was going to roll things over to thank you. And if there are further questions or things that need to be addressed, please reach out to us. And Sonia, were there any other thoughts or closing comments?
No, I hope we've answered your questions, and thank you very much for joining us today.
Oh, yes, before we do depart, and if my coworker always talked to others about how she dislikes or disapproves me behind my back, um, that bothers me, and also others who heard her talk, does that count as harassment? So for our definitions in our review today, it's really about developing your policies and procedures, and maybe not wise for us to answer things in that specific a context. But if you look at some of the resources that Sonia was just talking about momentarily ago, there are lots of definitions and things that you're describing there. Have a look, because it would be important that you consider talking to your supervisor, your manager. Sonia, anything else about that?
No, I agree with you, Sue. So take a look at your policy and program, contact your supervisor, and speak to the resources in your workplace. So human resources, health and safety committee, or representative.
We had a note from Rose here. The only experience I have had of this in the workplace was from volunteer society members. I don't know if they're expected to be legally responsible for their actions. I would easily say anyone who is participating in a workplace, be it paid or unpaid work, I believe that it will fall under very similar uh, requirements. Would you not say, Sonia?
I would agree. Again, come back to your workplace policy and program.
Well, folks, I think that does conclude everything that has been asked today. So thank you once again. It's been really an honor to be of service, and I'm sure that some of you, we would love to see all of you back for part 2. We will be broadcasting again tomorrow. And until then, please stay safe and take care.